Good morning. I think our microphones are all working and we're ready to go.
People around that way.
My name, as Sally mentioned, is Rich Fiesta. I'm the Executive Director of the Alliance for Retired Americans. The Alliance was formed by the AFL-CIO Executive Committee in 2001 to be the advocacy and policy organization for not only retirees of the AFL-CIO and its affiliated unions, but in general on issues like retirement and security, social insurance programs, labor laws as well. We have 4.4 million members and state and local chapters around the country. And as Sally mentioned, I'm a member of the National Consumers League Board of Directors and glad to be here today. Also a graduate of Georgetown Law. Glad that Alma Mater is hosting this as well. My connection to the FLSA is that in the mid-1980s, I was counsel to the then U.S. House Subcommittee on Labor Standards, which had legislative jurisdiction over the FLSA, and it was a time in particular of the 1985 amendments, which extended the FLSA to state and local workers after the Supreme Court 1985 decision in Garcia versus San Antonio Metropolitan Transit Authority, or SAMTA, as some people call it, which was a large expansion of the act that actually had overruled, the court did, of a previous case in the 70s that did not extend jurisdiction. So FLSA 80 years out is still expanding, changing, gaps, loopholes, and we'll talk about that as the day goes on. Anyone who came late, I've been asked to say there is CLE credit and to check at the registration desk with your barcode on your name tag in that area as well. So done the due diligence. So today we have a terrific panel of scholars and practitioners in Fair Labor Standards area. We're going to talk about how we got to the Act, how it was created, how it was first defended, and set the stage for the rest of the day. Sitting to my right is Kirsten Downey, former Washington Post reporter, but best known for her very good biography of Frances Perkins, who was, of course, Secretary of Labor of the United States. Before that was with then Governor Roosevelt in New York, and had been an advocate in labor in a number of areas for quite some time. Next to her is Lynne Reinhart, who is the General Counsel of the AFL-CIO, also a graduate of Georgetown Law, so mention that. Lynne has been involved in labor areas during her career. She worked for the U.S. Senate Labor Committee for a number of years as well before coming to the AFL-CIO. Well, next to Lynne is Professor Ruben Garcia of the William Boyd Law School at the University of Nevada, Las Vegas, where he is the co-director of the Workplace Law Program. Professor Garcia has practiced labor law, union-side labor law, before his academic career, and more importantly for today, he's also a Board of Directors member of the American Constitution Society. Next to Professor Garcia is Marlene Tressman, who, there she is, exactly, who's done a great thing. She's a lawyer turned author, thank you, and has written a wonderful biography of Betsy Margolin, who was a longtime Department of Labor lawyer, who was very important in the early years after the act of defending it and dealing with legal issues as well with it. And further at the end is Professor Robin Muncy of the University of Maryland, who has written a lot about reform and progressivism in the early 20th century. Her book, Creating a Feminine Dominion, American Reform, 1890 to 1935, covers the area leading up to the FLSA with people like Frances Perkins and Florence Kelley as well. She's also written a biography of Josephine Roach, who was a post-war lawyer, very important in the labor area, especially regarding the United Mine Workers, for example, as well. So with this great panel, let's continue. The 1937-38 was the passage. Congress considered this law. It was controversial. It did not show up overnight like a mushroom and did not parachute from the sky one afternoon in 1938. There was a lot of history and context before that, going back to the 19th century. So what happened pre-New Deal, pre-37, 38? Agitation, as Sally mentioned, for fair labor standards. The act gave us wage and hour laws. It addressed child labor. And I think most importantly, in some ways, an administrative law, for the first time, the federal government mandated that private employers, without a government contract hook, keep records so that compliance could be ensured. So it did quite a number of things in 1938, but how did we get there? Kirsten, Francis Perkins seemed to have had a role in this.
Well, hi, I'm Kirsten Downey. I come at this from two different angles. I was a longtime reporter at the Washington Post, where I wrote a lot about employment issues, and I had a column called On the Job, where people could write to me about their workplace problems, and I heard a lot about a lot of bad things that were going on. Not surprisingly, to sort of understand the context to this, I investigated a lot of the labor legislation we have, and came around to the recognition that there was really this phenomenal person named Francis Perkins, the most successful social progressive in American history, who was responsible for almost all of what we consider the New Deal. She's responsible for Social Security. The Fair Labor Standards Act wouldn't have happened without her. And for that matter, the Fair Labor Standards Act wouldn't have happened without the National Consumers League, because that's how far it went back. Frances Perkins joined the National Consumers League as a young official very early in her career, and pretty much adopted Florence Kelley's agenda, which was trying to find ways to reduce child labor, shorten work hours, and increase compensation. The way they spent 60 years basically on this effort. For Frances Perkins, we first see her active on this issue in 1907. The Fair Labor Standards Act passes in 1938. She's in the middle of every battle for the 30 years. And for the most part, it's so difficult to get any federal legislation at all passed in these areas that they do it very incrementally, going state by state. And the thing I think that Frances Perkins is most known for from the very beginning is doing her best to get workers as much as they could get at every opportunity that she had. In fact, they sort of called her the half-a-loaf girl. When she had a chance to decrease work hours back in 1911 for women in the state of New York, it was a 54-hour-a-week limitation. The Democrats who were backing it and who were pretending that they were enthusiastically backing it wrote the legislation in a way that deleted the cannery workers. And Frances Perkins at that point had to decide, would she go for a piece of legislation that would cover 400,000 people but injure 50,000, not provide them with the protection? Yes, she did. She got the protection for the 400,000. She had to go back the next year to try to get it for the women cannery workers, the other 50,000. And in fact, that was her whole key, and that is the legacy that she leaves us with the Fair Labor Standards Act. She did everything she could, and she left the rest for later, and that would be us.
Interesting.
Yeah, I think I would even start before Perkins. I see a crucial moment in the history of the Fair Labor Standards Act in the 1890s, when you see that sort of broad alliances, cross-class alliances being built at the state level. And I'm thinking of Illinois because of Florence Kelley, in fact, in Illinois in the early 1890s, when a bunch of middle-class women and their organizations and their social settlements, and this is pre-NCL, actually, they begin to make alliances with the labor movement in Illinois, and together they lobbied the state legislature in Illinois to get, these were hours laws and anti-child labor laws and factory safety laws, which Florence Kelley then became the factory inspector for. And though that much of that law was declared unconstitutional very shortly thereafter, those alliances remained, and those kinds of cross-class broad alliances were important in every state where those kinds of protective labor laws were finally passed. And Sally mentioned then that when the NCL was formed in 1899, becomes one of the leaders, but only one of the leaders in this set of alliances. And those alliances are going to continue through the decades thereafter, and continue not only to the passage of the Fair Labor Standards Act, but also in expanding it later, which I hope we have a chance to talk about as well.
Sure.
And I'm
Yeah.
afraid I'm going to have to go back even further to
right ahead.
January 1865, the passage of the 13th Amendment, which barred slavery and involuntary servitude within the United States. I'm part of a group called the 13th Amendment Project that is an interdisciplinary group trying to find the antecedents to the Fair Labor Standards Act, minimum wage, overtime, labor organizing, the minimum floor for labor standards. I think historically you can see elements of that in the Freedmen's Bureau in terms of setting of wages and contract regulation of labor. And so that is something, again, that I think we should, as we look forward, of course, to the next 80 years or more of the Fair Labor Standards Act, we have to continue to think about what, what happened in Reconstruction, not only, of course, in terms of the the badges and incidents of racial slavery, but also, of course, the setting of minimum labor standards. And I think that is also relevant going forward as we look to, or we continue to look at the many exemptions that the Fair Labor Standards Act has, right? So for agricultural workers, and again, we'll be talking about this more today, but for agricultural workers, for tipped workers, for domestic workers, I mean, these are all really badges and incidents of the racial politics of the 1930s, right? And we know, of course, the legislative history of the Act shows that it was very much about this, keeping the South in line, or keeping the South part of the package, right? And so that is something, again, I think that we have to keep looking toward, dealing with those exemptions. I call them margins in a book that I wrote that's right over there, marginal workers, and I call them the margins in the law that workers fall through, right? And I think the challenge for the next century is going to be, how do we fill these gaps? What ways do we fill those gaps? We fill them through constitutional principles, international human rights principles. These are all the things I think that the future of the FLSA really, calls us to look to.
Yes, all the way back. In fact, there was a federal 8-hour law in 1868 that was actually passed over the President Johnson, the first President Johnson, veto that applied to shipyard workers, most federal workers on the federal payroll, like the Brooklyn and Philadelphia naval shipyards, that had the word prevailing wage in it, for example. But what the feds did is there were 10 hours a day, 8-hour day, they just cut everybody's wages 20%. So not so good. But there are antecedents going back, 80 years before, the 80 years after where we are today. This case, Mueller versus Oregon, we hear a lot about that. Who wants to talk about that?
Sure, I'm glad to talk about that. That is a case that was brought by the National Consumers League with Brandeis, of course, at the person arguing it, but Josephine Goldmark, the person who put together the famous Brandeis brief, which was argued in 1908 before the Supreme Court. And it was a case, it was a maximum hours law in Oregon that was strictly for women, went strictly to women. It was a single-sex maximum hours law. And the brief argued that it would be, even though in Lochner in 1905, the Supreme Court had said that states could not set hours for most men, the brief argued that women had a special role in society and special disabilities in the labor market. That meant that the state could, in fact, regulate their hours, even though the state could not regulate men's hours. And the Supreme Court went along with that. So that in 1908, the Supreme Court ruled in response to the Mueller case that single-sex maximum hours laws were constitutional. And within a few years, I mean, Sally mentioned this in her introductory remarks, Bunting in 1917, actually another case brought by the NCL, in that case, the Supreme Court actually then did say, oh yeah, okay, well it is all right if the states regulate maximum hours for men as well. That case has an odd effect. It kind of lands and then makes no noise. It's one of those, it's a tree falling in the woods and nobody to hear it for some reason. But we get on the books, thanks to the NCL in 1908 and then 1917, Supreme Court decisions that say that it's all right for states to regulate maximum hours. However, there continue to be all kinds of, as I'm sure pretty much everybody in this room would know, a lot of controversy over minimum wages, and even the labor movement wasn't supportive of minimum wage laws. And so that minimum wage laws turned out to be much more controversial than maximum hours laws. Child labor, too, was a part of some of the early advocacy at the state levels, and in the beginning, in a lot of those early laws, state laws, child labor regulation is a part of maximum hours law and factory safety laws and that kind of thing. And then child labor begins to kind of split apart and take its own path, because there are attempts in teens, especially during World War I, there are attempts to get federal laws to regulate child labor, and there are a couple of big tries by women in the Children's Bureau to get that done, and the Supreme Court declares all 2 of them, declares them unconstitutional, and that's why the labor movement and women in the Children's Bureau and social settlements and the NCL try then to get a child labor amendment. And what the child labor amendment was supposed to be about was just giving Congress the power to regulate child labor. And that passes through Congress in 1924, but then is never ratified. Turns out, at least so far, it seems not to have been necessary. But it's interesting how the branches of these protective labor laws sometimes converge and sometimes diverge.
Rich, I'd like to just jump in and pick up on something that Robin said about the fact that organized labor was not altogether behind passage of the Fair Labor Standards Act. Just disclaimer, I'm not a labor historian. I'm not a law professor. I'm not an author of a fabulous book. You may be wondering, then, what is she doing on this panel? I had that same thought yesterday when I looked at the agenda and thought, okay, what am I going to talk about? So here is the general counsel of the AFL-CIO. I think I'm going to talk about organized labor and what our view was about the Fair Labor Standards Act and minimum standards legislation. And many in this room probably are aware, but all may not be aware, that the American Federation of Labor at the time did not support the Fair Labor Standards Act in 1935, 36, 37. And thinking about that now in the year 2018, after the labor movement has been front and center, pushing for, advocating for increases in the minimum wage, expansion of the minimum wage, pushing back against curtailment of the minimum wage for decades, it's a little bit surprising to go back to 1935 and think, well, the AFL didn't support the Fair Labor Standards Act. What's that about? This was what I was thinking about yesterday, because getting refreshed with this history. And a lot of the history is actually laid out in an article that was in the Monthly Labor Review in, I want to say, the year 2000, and I'm going to get this to Sally and Caroline to include in the materials for this session, by Howard Samuel, who was a labor leader and at the time was the head of the Industrial Union Department, the Coalition of Industrial Unions of the AFL-CIO. He happens to also be the late father of our current government affairs director at the AFL-CIO, so, it's all in the family. Anyhow, he wrote this really interesting article about the labor movement and its views on the Fair Labor Standards Act. And, like I say, it seems sort of shocking that the AFL initially didn't support the law. But if you think about it at the time, and in the times that we were in, this is 1937, 8. The Wagner Act establishing a right to collective bargaining and to unionization and to form a union without the government going to court or companies going to court to enjoin workers from forming a union or going on strike or trying to bargain for higher wages. That had just happened. We had just gotten the Wagner Act passed in 1935. We had just gotten the federal courts out of the labor business, enjoining workers coming together to form unions a few years prior to that. The Wagner Act had just been held constitutional in 1937. And so now here we are, 1937, 1938, and the question is, should the government move from being a regulator in its federal contracting system and not use the contracting system to keep up wages, not drive down wages. And there had been some of that going on. This was different. This was, as Rich said at the beginning, the federal government setting wages in private industry. And the view of the American Federation of Labor at the time was, no, thank you. We've got that. You've just allowed us to form unions. We can handle this through collective bargaining. We don't want the government setting wages. Thank you very much. We got this. And so different formulations were proposed, either to leave workers with collective bargaining agreements out of the law entirely, or to to say that, that those collective bargaining agreements would be a floor, not a ceiling, which is where the law ultimately landed. But there was a real push and pull about this whole idea of the government being in the business of setting wages, with the organized labor movement, or a good part of it at the time, saying, no, thank you, we want to cover this through collective bargaining. There were other unions and other labor leaders, John Lewis, who famously led unions out of the AFL to form the CIO, and was, a more progressive leader. Sidney Hillman, who was the head of the Clothing and Textile Workers Union, very much favored having a minimum wage law and setting a minimum standard that you could then build up from. But there was this concern about the government being in the business of setting wages, about the minimum becoming the maximum. You heard that a lot, and the minimum actually driving down wages. Ultimately, labor came to terms with it. The legislation was modified. It set a minimum. It didn't call it a minimum fair wage. That was something that John Lewis really objected to. He said, it's a minimum wage. Don't call it a fair wage. We're going to bargain for a fair wage. We're going to bargain for a living wage. This is a minimum wage. And that all got worked out. And so we have the Fair Labor Standards Act. Labor did support it. And as I say, labor has supported it strongly ever since. In fact, when John Sweeney got elected president of the AFL-CIO in 1995, he wrote a book called America Needs a Raise, and advocated for a raise in the minimum wage. So, this tension between, do you set minimum standards or do you achieve it through collective bargaining? The answer has ultimately turned out to be yes, both. And that's where we are today. So.
And all that's completely accurate. I just wanted to add, of course, that the FLSA probably wouldn't have happened had it not been for the change that the Norris-LaGuardia Act of 1932 and the National Labor Relations Act of 1935 really made, from the Wild West of laissez-faire, the employer can do whatever they want at the federal level, of course, with some state exceptions, right? But this was the watershed, groundwork, I think, for the FLSA really was the NLRA, because it really changed the dynamic forever in terms of the government's role in regulating the economy, and also the power that workers have vis-a-vis the employers. So I think it really would have happened that way.
Yeah, and I think I would also emphasize, even though the AFL was opposed to the minimum wage part of the FLSA, I would still say that there was no way that the FLSA would have passed without the support of organized labor. And the CIO was so important, and the women's unions, the women-dominated unions, were really important. And eventually, the AFL did come on board, and it was really just, as I understand it, I may have this wrong, so I understand it was really the minimum wage part that they opposed, that the maximum hours part, then the anti-child labor part. AFL was even on board for.
That's absolutely right.
So it's just a teeny part that they fought over. So I think that the importance of social movements, the importance of organized labor in creating the law in the first place, and then, as you say, expanding it later is absolutely central.
Frances Perkins didn't think it was the National Labor Relations Act that had anything to do with it. She really thought it was the National Industrial Recovery Act that happened before that employers had voluntarily signed up in trade associations during the Depression to basically set aside antitrust laws. They set, and in agreement to get permission to set aside antitrust laws, they said that they would establish other criteria that were a lot more worker friendly. And so corporations on their own in the early 30s set minimum wages, they set limitations on work hours, and they began banning child labor. Well, the Supreme Court, the almost always conservative Supreme Court, set the National Recovery Administration aside, overturned it, but it meant that all over America, companies had voluntarily agreed to a minimum wage and to cut their hours and to ban child labor. It was very hard for them to say, I know we've been doing that, but now we don't want to do it anymore. In fact, they had imposed it on themselves. And it made it much easier to pass legislation that enshrined what companies had already agreed to do on their own.
Very important point. So I'm seeing we have the 30 to 40 years before FLSA, these threads looking at our constitutional federal system in the states of maximum hours, minimum wages, child labor, progressive governments, state governments at the time, passing legislation. A couple of them, there's gender issues that just seem so foreign to us today, but actually played a role in upholding some of these laws as well. some World War I legislation regarding railroads and wage and hours that the Supreme Court actually did uphold, which was a fine thing to do, something called the Addison Act, for example. So all of this comes together, great change in federal government in 32. So here we are, 33 National NIRA, National Industrial Recovery Act. We had Davis-Bacon actually under the Hoover administration for wages on construction. Social Security, you can say, is a workplace-based law because your benefits are based on your work. So it comes to 1937-38, second term of the Roosevelt administration. What were FDR and Francis Perkins thinking moving towards FLSA?
Well, it was very interesting. Francis Perkins thought that they could have gotten the FLSA through sooner, but FDR decided to hold back on it so that it would boost the chances for big Democratic victories in the 1938 midterm elections. So just an interesting thought. It might have, but I'd say but they knew it would have a huge and positive effect on the American workforce. So they knew it would be the one thing that would really connect with people all across the country. And I know when I was researching my book, that point was made really clear to me when I met a very old man, who told me about the first time he had gotten out of work while the sun was still out. He'd spent his entire work life working 12 hours a day during the week and 17 hours a day on Saturdays. And on the day the FLSA went into effect, it meant that he could walk out of his office at the end of the day and have a couple of hours of sunlight before the sunset, and how incredibly grateful he felt to FDR for doing that.
Quite a powerful story, and just replicated, you can think, many, many, many millions of times around the country. So who were the key people, 37, 38? Obviously, Francis Perkins, FDR. Who else? Who else was
Margolin.
Yes, we'll get to her in a bit. We need her after it's passed. Robin.
Yeah, I think John L. Lewis is another one of the major players there. I think we'd have to say, as he organized so many unions to support the law, and then people like Mary Norton. We were talking a little bit about her before we got up here. Mary Norton. How many of you ever heard of Mary Norton?
There's one.
Yeah, okay. You're from New Jersey, right?
That's right. Are you from New Jersey?
From New Jersey. So she's somebody I wish I knew a lot more about. But
we all do.
She had become she's a congresswoman from New Jersey. She had gotten elected in the early 1920s. And one of the things I find so interesting about her is that she actually was not a suffragist, not a person who supported women's suffrage or the 19th Amendment. And yet, when that amendment passed and women were enfranchised finally in New Jersey, the Democratic machine basically came to her because she was a leader in daycare?
Yes.
Daycare. So the major organizer of daycare, having lost a child of her own in I think the teens, something like that. Anyway, so she had a presence, a public presence, but she was not particularly interested in electoral politics. But she was so good as a public leader that the leaders of the Democratic machine in New Jersey came to her and said, "We want you to run for office." And didn't she head the Democratic Party in New Jersey too?
Yes.
So she gets elected in the early 20s, and she's there forever,
26 years.
26 years, thank you. And so and she's a huge supporter of labor. She's a pro-labor vote consistently through her career. And in 37, she became the chair of the House Labor Committee. And she is really important in moving that, not only in moving the legislation out of the committee, getting it onto the floor, but also in the negotiations that went on, that were in these battles, especially over the minimum wage part of that law, as the AFL and others were fighting over the particular shape that would take. She is in there supplying alternatives and that kind of thing, and ultimately helps to negotiate the bargain that passes. So she needs a lot more attention, I think. Really interesting character.
Yes. The first Democrat elected to the U.S. House of Representatives. The previous women, Jeanette Rankin and all, had been Republicans. And in 1924, she was the first woman Democrat elected, and she served until she retired in 1950. Lived about 8 or 9 more years beyond that.
Really
so
interesting.
Are there any budding biographers out here? There is a lot of Mary Teresa Hopkins Norton of Hudson County, New Jersey, but was very important. This was not an easy bill to get through Congress. In the day, much unlike today, the Rules Committee was not controlled by the Speaker. It was on its own, and it refused at times, even though a New Yorker, a conservative New Yorker, was the chair, and refused to bring it to the floor in 37. And they used a rarely used thing today called a discharge petition, where 218 members have to sign saying we want this bill brought to the floor. And the first attempt to get it on the floor came through this discharge petition. And then Congress, because the Southern Democrats in particular were upset at a 40-cent minimum wage, the law later came out at 25%, thought this was too much, so they voted to send it back to committee, to Mary Norton's committee, where a lot of this back and forth went on whether or not we're going to have a minimum wage or wage boards like the NIRA. And then a second discharge petition, finally in 38, got it out to the floor. It's just using procedures that are very rarely used, almost never used today. But this was not a slam dunk, as it were, in spite of all this other previous New Deal legislation before it, because this was for the time, a radical change of the government setting standards in private industry without the hook of a government contract or some sort of government direct work in it as well.
Can I just jump in on that, just to say that this whole issue of whether or not it was wage boards who could go out and set wages in a particular industry, or a set across-the-board minimum wage to be enforced by an administrator, David Weil, 40 cents, was a really key issue at the time the Fair Labor Standards Act was adopted. And the fact that it ultimately was an across-the-board 40% minimum, 40 cent minimum, not 40% minimum, 40 cent minimum, enforced by an administrator and not wage boards who could, take it up or down and scrutinize collective bargaining agreements and all of that, was a really key reform that led the AFL to support the legislation and the CIO to support the legislation and other labor leaders to support the legislation, which kind of unlocked the hold that some other members of Congress had on it and allowed the law to pass and get in the books. And just one other comment is that on your comments about Mary Norton and the hearings and the whole debate in the committee, it's really striking when you go back and read some of those committee hearings and the testimony at the time. It's pages and pages and pages and pages of back and forth and Q&A with the different witnesses who came before the committee. Very deep, very substantive, and contrasting that to how hearings go in Congress today is just sort of interesting. Yeah.
They aren't people reading press releases into the microphone like today.
It's not the kabuki. Yeah, it's not the kabuki thing you see today. It was deep and real. With
a lot of economic data behind it, too. An achievement for the New Deal for workers. How much of the American economy did this law affect? Much? Not a lot? I've read maybe only 20% of the workforce. Ruben, if you
Well, again, I think, as I said earlier, I mean, it exempted large portions of the economy at the time, like agricultural workers and domestic workers. And so I think that it's hard to know exactly what the percentage was at the time. As we know, I mean, the coverage or the way it was designed was broadly in favor of coverage. It was broadly in favor of most people are going to be considered employees, and I think it's still the case today. And so I think that again, in terms of the impact on commerce, obviously that had to wait for the switch in time that saved 9. The decision in the West Coast Hotel versus Parish case in 1987 that held the act, the broad conception of commerce. So again, at the time, probably because of the narrowed conception of what the Congress thought of as commerce, they probably didn't conceive of it as perhaps covering as many workers as it ultimately did. But clearly, even though we have broad commerce coverage today, there are still pockets of the economy that aren't covered by the act, and again, in terms of some states where you don't have even a state minimum wage, like South Carolina, Mississippi, Alabama, Louisiana, Tennessee, don't have state minimum wage laws, right? So it was very much created, I think, as even in its broad sort of commerce coverage is having a lot of gaps and a bit of a patchwork in terms of what it ultimately ended up
11 million people were covered, 300,000 were exempted. 11 million covered, 300,000 exempted. Exempted domestic workers, farm workers, sadly exempted. Remains to be, fully fixed.
And at that time, state and local workers, too.
I'd like to
Yeah.
jump in at this
Sure.
point, and I apologize to those of you around the corner. If you want to move over, you might see us. I can't see you over there. But the piece I bring to this distinguished panel is the enforcement of once the law was passed, and the lesson that no law will ever be any stronger than the extent to which it's enforced. So when Betsy Margolin joined the Labor Department, or the Wage and Hour Administration for the General Counsel's Office in 1939, March of 1939, Frances Perkins was waiting to put teeth into this wonderful law. And Betsy Margolin, I'll digress sort of, but it's very pertinent, had come from the Tennessee Valley Authority, a New Deal cornerstone where Congress had just realized FDR's vision of supplying electricity to the Tennessee Valley's most impoverished residents. And it was there that this amazing, and I say audacious lawyer, who was one of America's 2% of women lawyers at a time when women were discouraged, if not outright prevented from practicing law as men were, she brought with her these notions of social justice that the New Deal had. And she was completely cognizant of how many people were left out of the Fair Labor Standards Act, which she was on the staff to enforce. But she considered it a first step. It was a first step in the right direction. In addition to the exclusions or exemptions for the agricultural and domestic workers, there were other carve-outs for railroad workers and all sorts of things. But she was a New Dealer. And like many of you, especially those from the Labor Department who have the law that's passed and have that to enforce, they brought with it this sense of social justice and the true humanitarian purposes and remedial purposes that Congress intended. And that was what they brought to this act. I'll just tell you for a moment, because I bet most of you, if you didn't know who Mary Norton was, you've never heard of Betsy Margolin. But she represents those countless and faceless, nameless employees, career servants who are there day in and day out, tedious, incremental, baby step forward in enforcing a law and 3 steps back, and have to wait out the wonderful interplay when it's done right of the 3 branches of government, where an executive agency takes a law and gives it teeth, waits for a challenge. Congress, the courts get into it, they defend it there, and if necessary, Congress is back in to amend it and adjust it. And it requires that all 3 branches of government, am I making you wistful, are acting up to their full potential, and requires an executive agency that brings to the table the purpose of the law. I'll tell you that Betsy Margolin spent 33 years at the Labor Department from 1939 to 1972. She served under 6 presidents from FDR to Nixon, 9 labor secretaries, beginning with Frances Perkins, and 11 labor solicitors. Most importantly, as first a senior attorney, and in fact, she had to convince Calvert Magruder, the first general counsel to the Wage and Hour Administration, that she was worth the $5,600 a year she wanted coming from the TVA as a constitutional litigator, because he believed that was an awful lot for a girl. And she ended up taking a lateral move at $5,000. Which is also part of the history of the workers who were behind the Fair Labor Standards Act. She argued 24 times at the Supreme Court, making her one of only 3 women in the 20th century to do so. She prevailed in 21 of the cases for which she argued, and they all dealt with the Fair Labor Standards Act or one of the peripheral, Davis-Bacon and some of the other, but all to protect America's workers. It's that vision and that the tedium. She was there as every aspect of this law was challenged, from Darby And in fact, within her first year on the job, she was sent down to the Fifth Circuit to participate in a federal judges conference. Fifth Circuit Judge Rufus Foster. They were looking at this case, Cotton Mills versus Administrator, which was challenging the constitutionality of the minimum wage set for textile workers, which was then 32.5 cents an hour. And Bessie was brought in, as junior as she was, because A, Rufus Foster had presided over one of the cases that went to the Supreme Court successfully for the TVA. Rufus Foster had been dean of Tulane Law School, where Bessie was civil law review editor, and she knew how to fashion briefs in cases bound for the Supreme Court from her work at the TVA with the same kind of social justice. So she brings to bear both the nobility of the work of the public service that is necessary in putting the teeth in these laws, and how important it is for all branches of government to get on the same page, and especially for the agency that's entrusted with enforcing a vital piece of social legislation to bring to bear all that Congress intended. So I'll stop for now and jump in.
Keep going. No.
I wish Betsy Margolin was around today to defend the Fair Labor Standards Act before the judiciary, which according to today's New York Times is being filled by nominees who are being vetted for their commitment to tearing down the administrative state. We need Betsy Margolin today. Yeah.
Robin, you were...
I mean, this was going to take us back to exemptions, and I don't know if we want to do that, but one thing, I mean, the latest statistics I've seen, I know it's really hard to figure out, but only 20 to 33% of American workers were covered by the original act, and you know, the minimum wage itself was so low because it was 25 cents in the beginning and went up to 40 cents an hour, and of course, most men actually made that much and more already, but the women who were among the women who were exempted, domestic servants, agricultural laborers, secretaries, and the like, over 60% of the women who were exempted did not make what was the minimum wage, that pathetic minimum wage. So the exclusions were really horrific. I mean, the people who needed the coverage the most didn't get covered, and so the sort of subsequent history of the act, it seems to me, is about trying to expand it to cover the people who needed that help the most.
And restrict exemptions as well.
Exactly.
And that was a large part of what Bessie was doing with the retail establishment exemption to make sure, and it was her first Supreme Court argument that set the stage under Phillips v. Walling, that exemptions were to be narrowly construed. So it was, you know, that kind of incremental basis that the lawyers and working with the investigators, trying to make sure that both the coverage was as broad and the exemptions were as narrow as Congress intended.
I'd say the biggest single disappointment with the Fair Labor Standards Act is that they didn't achieve what they had really hoped to get, which was a living wage. And of course, that still bedevils us today, and that it was never adequately adjusted for inflation. And we've just seen that play out again and again in recent years.
And there have been attempts, as the minimum wage has been raised through the years, to add an inflation adjustment, much like we did in the 70s for Social Security, but Congress has not seen fit to do that, and yet we're stuck with minimum wages that are far below even a poverty level if you're working full-time,
well, that's where, you know, one of the provisions in the Fair Labor Standards Act that has served as a model for other labor legislation really comes into play and is so important, which is that the federal Fair Labor Standards Act is a floor, very explicitly a floor, not a ceiling, and it very explicitly authorizes states and cities to go beyond and set more protective and better wages than the federal government sets. And that's turned out to be a really good thing because we're so stuck here in Washington at such a pitiful minimum wage level. And a lot of other laws have adopted that, establishing labor standards as a floor and letting cities and states go up from there. OSHA, Family and Medical Leave Act, so on and so forth. And I think and it's interesting, as I understand it, very little happened in the way of state or particularly local increases in the minimum wage beyond where the federal level was set for a long period of time. But really in the last 20, 30 years, we've seen an explosion of activity, especially at the local level, but also at the state level, to get closer to the living wage that Kirstin just mentioned. And some really interesting innovations have come along with that, where cities and states, mostly cities, have adopted closer to a living wage and then have added other things on to build out the protections for workers. And so in a number of cities around the country, they've established a living wage, but they also add on that workers on service contracts, when they turn over, get to keep their jobs, worker retention provisions, or they add on that employers also have to provide some paid sick days, or they add on that employers have to be neutral when their workers are trying to form a union, and so forth. And I just think it's kind of interesting because going back to what I said at the beginning about the American Federation of Labor in relation to the Fair Labor Standards Act saying basically don't set a minimum wage. We've got that through collective bargaining, and this tension between what you can achieve through collective bargaining and what you can achieve through labor standards legislation. In the cities, you're seeing that kind of get married together so that it's an ordinance that does both. You know, it builds minimum wages, but then it also builds worker power through some of these other measures that promote collective action and collective bargaining. And the last point I'll make on this is that because it's been so successful and effective, it has been challenged. And, you know, the business community doesn't particularly like these progressive ordinances at the local level and have moved to challenge them on their own, but increasingly in states have moved to preempt cities from being able to even go in this area to adopt higher minimum wages and other labor protective legislation. And, you know, we saw this in Missouri where St. Louis and Kansas City adopted living wages and the state legislature came in and cut it off. We saw this in several other states. And so with success comes a counter reaction and a pushback. We've got that push and pull going on. In Alabama, as you mentioned, no state minimum wage, but the city of Birmingham set a minimum wage that was attempting to be, you know, a living wage that was going to cover 40,000 people, and the state came in and cut it off. And interestingly, there's a lawsuit against that saying that the all-white majority of the legislature that repealed a wage increase for 40,000 largely African-American people in Birmingham, Alabama, violated their constitutional rights. And I don't know if somebody here knows the status of that lawsuit, but I just was so thrilled to see the pushback because it was such a obnoxious move to take a pay increase away from these well-deserving workers. So.
Right, and again,
Ruben, then
the local is going to be incredibly important now, and as Lynn was saying, you know, those. I was proud to be part of the Los Angeles Alliance for the New Economy, a legal team that created the living wage ordinance in Los Angeles, which was, you know, set to service contracts, you know, like the service contract, the Walsh-Healy Act. But that spread, of course, through, you know, it was not tied explicitly to doing business with the city, right? And so obviously that was a big movement in the 90s that has continued. And as Lynn was saying, you know, the reaction to that, you know, at the state level has been met, I think, with a very intriguing coalition of civil rights and labor kind of arguments sort of coming together in Alabama and in other places. So I too looking, you know, following that lawsuit carefully. But again, I think we have to remember, you know, as important as the FLSA was, how much it left, as Lynn was saying, you know, to the states or to the employer, right? So no sick leave, you know, no paid break time, you know, no vacation time, right? Just all the things that, as important as what it did, you know, still left, you know, unsaid about the employer-employee relationship, and obviously, states have had to fill in that gap, you know, in many different ways.
Yeah, I just sort of a hopeful note there, maybe, it is that.
Please.
Yeah. Because the way I see the way that the FLSA emerged in the first place is that there's, you know, decades and decades of activity and struggle at the local and state levels, right? And there are strides made, and then they're forced back, and then you rearrange things and you try again, and that's happening all the way up to the 1930s at the state level. And the Great Depression, which no one could possibly have predicted, provided, whoa, this big political opening, right, for all these experiments that had been going on at the state and local level, now to get pushed up to the federal level and have the possibility of passage there. And we never know when that opening is going to come for us at the federal level, it seems to me. And so even when it's nothing but struggle at the local level, and we're losing almost as much as we're winning, keeping that stuff alive is what it's about, because we never know when the big opening is going to come.
That's right. For 2 years after FLSA, Congress then sort of did its first amendment of sorts called the Portal to Portal Act. John L. Lewis, again, for the Portal to Portal Act, it was the practice, especially in the coal mining industry, that workers did not get paid until they hit the coal face. So you could be walking or on your trolley for half an hour, and you weren't paid. And then the same coming back as well. Now, you could, some cases get that through collective bargaining, but Congress then passed an amendment, the Portal to Portal Act, which made when you get in the trolley and you hit the rails, you're getting paid under the Fair Labor Standards Act as well. And then after the war, there have been many changes and expansions in domestic areas as well, along with regular minimum wage increases over time as well. But again, fits and starts.
And also, you know, in addition to the positive reform that you just mentioned in the Portal to Portal Act, Congress also included provisions that modified how you do private enforcement of the Fair Labor Standards Act, and kind of messed it up. So that's an area where the Fair Labor Standards Act is not a model for other labor and employment laws, because there's no class action. People have to opt in explicitly, and if the Secretary of Labor brings a case, it can cut off private litigation. It's not a model that has been replicated, and for good reason. So,
I see we're getting close to our question and answer time. If any panelists wanted to conclude, otherwise we can move straight to any questions from the audience. Yes, start right here. I guess we should. Oh, that's our staff person.
Right.
But if you have a question, yes, red badge. So if you just say your name and who you're from, see one there, and second one over here, third one in the front.
My question is about the enforcement during the first, say, 20 years after the passage. It seems like per capita there were probably more wage and hour investigators then than there are today, and also kind of the quality of efforts at enforcement. There was contingent labor arrangements where employers were trying to escape the minimum wage and overtime back then, and there were successful efforts in the Supreme Court to limit that. I wonder about your perception of the enforcement in the first 20, 25 years.
Well, speaking from the perspective I got of being Betsy Margolin's biographer, it was take battles that were important and where the facts laid and where they could be taken. She spent her first years as this senior attorney in damp warehouses, reviewing payroll records and timesheets with investigators. I can't speak to the numbers, but they knew it was important to accumulate the facts. In fact, she was ready to give up because it was so tedious and dreary. She thought that her condemnation work for the TVA was starting to look better than what she was doing. It was very tedious work. And every battle, and it's amazing, and as someone in my own legal practice with the state of Maryland, I could really appreciate, the first week she was on the job, she was sent down to New Orleans to quash subpoenas that had been, from their perspective at the Labor Department, improperly served on wage and hour administrator Elmer Andrews while he was giving a speech. Every aspect of the law had to be challenged and enforced. And I think it gives great hope for those who work in the trenches of keeping the long view, of not taking the district court's adverse decision as the end of the road, but developing the case with the investigators, with the people who were issuing the administrative bulletins, the interpretive bulletins, and taking that long view, waiting for the right moment. The one other thing I'll talk about is Betsy developed what seems common sense, but it was landmark at the time. She issued over her tenure some 200, 250, what she called, there was sort of letters of advice, these interpretive memos, I'm blanking on the name, and each one was to make sure that all of the lawyers within the DC office and all the regional attorneys were kept apprised of the latest developments in the circuit courts, and by 1945, she had argued in Fair Labor Standards Act cases in every circuit court in the country, that everybody was kept apprised of the latest developments, the latest definitions, and to what the cases should look like, that they should be looking for to take up, knowing that the courts would only take baby steps, making sure that leaps weren't too big. So it was both passionate but conservative. That's what enforcement was like, and you know, it struck me as sort of a wonderful, okay, stick with it for those who have long-term careers in enforcing statutes. Once the constitutionality was defended and upheld in Opp and Darby, it was the rubber met the road on every facet. Injunctions, making sure that judges actually issued injunctions when they found a violation. Bessie took that as a real personal battle, because without the injunction, a second violation meant that the Labor Department couldn't get the contempt order, which was their mechanism for getting back pay and wages. And it was that. It wasn't the grandiose, big, issues. It was bringing dignity and excellence in the law in achieving those very tiny steps forward. That's what it was like for her 33 years. And I'll just give a shout out, since it's also the 55th anniversary of the Equal Pay Act, which when that passed fell to Betsy Margolin as well to oversee. They did it with all of the experience they had garnered from the Fair Labor Standards Act and the same long view, picking the right cases. And by the time she retired, she had overseen the filing of 300 Equal Pay Act suits in 40 states, recovering millions of dollars for thousands of employees, and earning the title of the nation's #1 fighter for equal pay for women. It's tedious work, but it's important work.
It's an important perspective, especially, again, I was asked earlier, was it any more polarized then than it is today? And that's important evidence to say that it was very polarizing even then, right? And I think it's really critical to remember that, in the long view, right? And again, I think in the end, we have to remember the 1947 Act also, just like 1947 was the year that Taft-Hartley passed, and that was also kind of an attempt to kind of retrench, the progress that had been made, right? So who knows? I mean, it could get even more polarized, and we could see another, retrenchment in terms of. I mean, obviously, this legislation over the weekend, in terms of the tip, was a good step. But I mean, we have to remember there's always a possibility for backsliding as well, as far as legislation goes.
In addition to what Marlene just explained very hard, was how painstaking the work was and how difficult it was. The people, Francis Perkins and the people at the Labor Department, got a terrible amount of public criticism because the newspaper industry did not want the National Labor Relations Act to pass. They mobilized to fight the National Labor Relations Act and wage and hour legislation. So what you had is reporters having to make the decision whether they would suck up to their bosses or try to report dispassionately on what was happening in the cases. And sad to say, a lot of reporters in the Depression were very eager to curry favor with their bosses. So even when they were personally very grateful for work that was being done at the Labor Department, what you'd see in press was criticism of how bureaucratic it was, how much it was interfering with the rights of business.
And the First Amendment, because the newspapers took the position that applying the Fair Labor Standards Act to the newspaper business, it was a case Bessie won at the Sixth Circuit in 1943, violated the First Amendment. So, and fortunately, the Supreme Court denied cert from that win. But she was up against the newspaper.
They're still trying that argument with respect to the National Labor Relations Act and workers' rights to organize. So, but on your point about the reporters, there's been some great coverage in the LA Times.
Yeah, recently unionized LA Times.
Hello.
Yeah.
My name is Reva Rubenstein. I'm here as a private citizen. On the question of maximum hours and the hours that people could work, the portal-to-portal thing was, of course, the landmark issue, but there were split shifts for telephone workers. You'd come in the morning, and then you had to come back at night. If you were a subway worker, before the Transport Workers Union was organized, you worked in the morning, and then you you didn't get laid off. You were off for like 5 or 6 hours before the rush hour, and then you were back again. And there was no remedy for that, or was there in the Fair Labor Standards Act? One other comment I have to make. I have to tell you that $5,600 in the 30s was a hell of a lot of money.
She only got 5,000.
Just saying. Anyway, thank you.
But that's what the men were earning, and so the point was whether she was entitled to the same.
But just on that, again, the FLSA applies to more than 40 hours in a work week, but states can have rules in terms of having more than 8 hours in a day and a work day. And so, again, the importance of state and local kind of innovations to fill in the gaps that the FLSA doesn't.
Not to show off that I did read my morning newspapers before I came here this morning, but there's a really interesting article about how the Gap has found, they did this study, and they've found that giving employees scheduling advance notice of scheduling and set schedules and not split shifts, but actually a regular day improves productivity.
Surprise. Yes.
And they're thinking of expanding it.
Sure. Yeah, Rob.
Yeah, I think the question of maximum hours and the way that it was structured in the FLSA is really important because it did not, one of the things that it still does not do is to forbid an employer from requiring overtime. So I mean, what the law, I mean, so mandatory overtime is absolutely legal, and that worked. So the law simply to discourage it requires an employer to pay time and a half after 40 hours. But the employer can say a condition of your employment is that you work 60 hours. I'm just going to pay you more when it's past 40. And that worked to such a disadvantage of women because so many women had domestic responsibilities and especially childcare responsibilities. And so if the employer came in and said at 5 o'clock, I'm going to have to keep you till 8, she has to lose her job because her kid will be on the curb at 6. So the way that's mandatory overtime is something I think we really need to talk about. I mean, it's deeply inhumane in my view, and it's certainly anti-family, and has worked to such a disadvantage for women because there are so many jobs that women just couldn't take because of mandatory overtime. And there's a big fight, among women workers in the 40s and into the late 60s about state laws that, so there were states that had laws that said that women couldn't work over 40 hours a week, and those took priority over the Fair Labor Standards Act, of course. And there are a lot of women who are very devoted to those laws because they needed the time to pick up their kids, for instance, and take care of their families. And there's this big battle in the 1960s about those special protective labor laws for women only, and the women who worked so hard and wanted so much to keep those laws that protected them from mandatory overtime lost. And what we have now is a labor regime in which basically if you can't fit into, to be the kind of worker that men could be when they had families at home to take care of them, if you can't fit into that model, you don't benefit much. Mandatory overtime, I think, is something we really need to take on.
Yeah. Caroline.
Hi. So what an amazing panel. I really have to thank you. This has been fascinating and interesting. So I'm deeply grateful to all of you for being here. And I had a question that sort of followed on the conversation about the newspaper industry, and it just triggered in my mind a vague memory that newspaper delivery, I guess they were called boys in the statute, but call them children, were exempted under the law. And of course, we've discussed farm workers and domestic workers, which are the larger categories. But if I recall, there are a whole variety of different weird little exemptions. And I wonder if anybody has some overview of that history. And I imagine it involves lobbying and money and industries that had leverage. But I just think that's kind of fascinating to unpack. There was laundry workers for some period of time, which I think also had a lot to do with racism. But does any of you have some background into that and can illuminate a little bit of that for me?
Literally a laundry list.
Yes.
Recreational amusement workers, service advisors at car dealerships.
That's the one I was going to bring up.
Supreme Court.
Rural
clergy
telephone
and church
operators,
workers.
for example. There aren't that many left, but they were exempt, or still are exempt.
But yeah, I mean, I think it is really a political issue, an issue of political power, and I think one of the points I made in my book was that these workers or these exemptions are really the result of political power and interests that are able to get them, and the workers that are affected by them don't have the same kind of organization, don't have the same ability to change the laws for their own benefit. So really talking about a political gap here in terms of actually getting some of these exemptions written out of the law, and so that's why you have cases before the Supreme Court trying to narrow or expand them.
And on the theme of everything old is new again, as the FLSA has been amended over the years, there has been this political dynamic, and unfortunately, additional exemptions have been added because of this dynamic. 10 years ago, certain computer programmers got exempted. Right now, I mean, I'm pretty worried that all these platform companies are running around saying it's the gig economy. That's different. The Fair Labor Standards Act can't possibly apply to us. We totally disagree. We think that there's clear coverage there, but the power dynamic that has led is continuing to lead to workers being excluded from this all important law continues to this day.
I think time for, yes, in the front, Debbie.
Lynn, thank you for your description of the AFL-CIO's concerns, but I wanted to ask a question that would tease out, Robin, what you mentioned about the needle trade support for wage and hour legislation. I think it is important to understand how Sidney Hillman saw, because of the structure of the contracting and subcontracting going on in the needle trades in the 10s and the 20s, how he saw both collective bargaining and establishing a floor for minimum wage and hours as important for protections there, because I think it is relevant to the contracting and subcontracting going on today. So if you could talk a little bit more about that alliance, Robin or somebody else.
I think you've actually just done a really good job of describing actually, I think you've done it for us, because there's in the needle trades, there was so much subcontracting, and there's so many little bitty concerns that all build up to be are all parts of sometimes a major enterprise, but sometimes actually pretty small. And Sidney Hillman was sort of the genius of organizing that in the 1920s, it seems to me, to see that the ways that those small enterprises and subcontractors needed to be brought into an organization that then bargained for them all. So it was a very different organization of an industry from coal, for instance, and that I think contributed to his sense that if everybody's going to be lifted up and there isn't going to be lots of competition destroying the wage structure within the industry itself, there has to be some sort of minimum, a floor set. So I think that you actually did the job for us there.
And I would just add to that, and we're not going to have time to talk about this, but two other words that were an innovation in the Fair Labor Standards Act that gave great power to what Sidney Hillman was trying to accomplish: hot cargo, and the ability of the government to basically take goods out of commerce if they were produced in violation of minimum wage and child labor laws. And that was very much about the needle industries and other really low wage industries. Very powerful, really fantastic, and scares the bejesus out of everybody. So we haven't seen it in any other law, right?
Another innovation, like making private sector people keep records, that you could actually take something and exclude it from commerce.
I have a question here before you give me the hook, Rich. I'm going to jump in with a question and just a comment. I think it's so critically important that all of you, with a couple of exceptions, but who've written books, about the history of these really important figures in labor history, which have helped guide me as a public interest advocate, how you get stuff done. If you haven't read, Ruben, I apologize, I haven't read your book. Lynn, I'm looking forward to your book. You know, Robin and Marlene and Kirstin got to read this history because it's just, it's wonderfully written, and it is such great guidance for those of us who are, you know, in working in the, laboring in the fields day in and day out. Question about what Kirstin said, the half-loaf girl. It's a really interesting advocacy challenge always to, you know, not try to get everything or insist on getting everything and go for a half loaf. In some cases it works, like Florence Kelley and Frances Perkins entering wedge when it came to including men under the maximum hours laws. But it hasn't worked out very well for agricultural workers, domestic workers, and a whole series of other exempted workers under the Fair Labor Standards Act. I may be opening up, you know, much too big a topic for the end of the panel, but I would love you to, as panel members, to talk about how we reflect on history and how we use that half a loaf concept to try to get our work done.
I will say a word about that because the way, and this doesn't go to the half loaf from the 1930s point of view, but what happens later, because there are these major expansions in 61, 66, and 74, the coverage of the Fair Labor Standards Act, and agricultural laborers in great big enterprises were covered in the 1966 expansion, and the labor movement was absolutely crucial in that. They're the people who came and made all the arguments and did all the research and made that possible and argued in the context of the war on poverty, you want an anti-poverty measure, let's raise the minimum wage and expand its coverage. And they were successful in that and getting a whole slim. That's actually, it's a 66 expansion that also brought hotel and restaurant workers in under the coverage of the act, but also then created the tipped wage
differential.
Differential, thank you very much, yeah. And then in 74, finally, domestic workers actually are brought under the coverage of the Fair Labor Standards Act. And the way that happened, what's so crucial here to me, is that the way that happened is organization, again, those broad alliances, cross-class organizations. In the case of the 74 expansion to domestic workers, which was really hard to get because homes were not imagined to be, by policymakers, work sites. You know, workplaces. There had been, you know, good cultural work done to separate homes from work sites, and so it's hard to get domestic workers covered by anything that's about imagining homes as workplaces. But there's success in 1974. And the way that happened was that there's a group actually formed originally by the Women's Bureau in the Federal Department of Labor, the National Committee on Household Employment, which then organized that's a group of mostly middle-class women, a black feminist, Edith Barksdale Sloan, took it over in the late 1960s, and she then went about organizing domestic workers themselves in the Household Technicians of America. There's like 25,000 women organized into that group by the late 1960s, and that group then took the lead in reaching out to the labor movement. George Meany comes on board then in the early 1970s, the National Organization for Women, the National Women's Political Caucus, the National Federation of Business and Professional Women are on board. And this is a really broad coalition, and Shirley Chisholm becomes a major advocate in the Congress itself. She brings on then the Black Political Caucus, as well as most of, but not in the whole of the Women's Political Caucus. And they argue and argue and argue. They testify before Congress beginning in 1971, 72, and in 74 they win this remarkable expansion, really, although there are going to be exceptions the next year made that exclude home care workers, which needs a lot of attention now. But
just one last thing in response to what you said, Sally. I think there could be a lot done now about connecting homelessness to wages and a lot more public discussion of it. Everyone is affected by homelessness right now, and so many of the homeless people are actually employed, but employed at very low wages. And we're trying to spend a lot of money to fix the problem, and people are coming forward with new sums of money, but the problem isn't going to be fixed until wages rise. And I think that's something that should, a connection that could be drawn a lot more explicitly in editorials around the country.
Just to close on that point, the PBS NewsHour last night did a segment on workers in Anaheim, California, many of whom have a union contract at the largest employer in Anaheim, the mouse himself, Disney, who cannot afford housing. And that the real living wage in Anaheim should be about $24 an hour. And even union contracts in the $15, $16 an hour do not make it. We're used an example of a 20-plus year employee living homeless at times with other people and the like there. So I know we have to go, but I want to thank this panel tremendously. I thought this was a good way to start the 80th anniversary. Thank you.